for CBS Brokerage. Today I'll be discussing the topic of establishing a revocable trust, oftentimes to hold life insurance. So oftentimes it's the case that revocable trusts are established simply to own a life insurance policy for somebody who has a federally taxable estate, for example. But I'm going to discuss the benefits of a two-trust design with two spouses, each having their own separate trust, versus a survivorship design where you have a one trust holding a survivorship policy with both spouses being grantors of that trust. Now the benefit of this design is that it's very simple. You have one trust holding one policy. Oftentimes it's done transactionally, so it's not a thought of how to use it for anything else. And so the problem with that oftentimes, as I see, is how people who have federally taxable estates need to establish other trusts for other transactions or amend the existing trust. What I would recommend in an ideal world, it's a little more complex in the sense that you would establish two trusts with each spouse owning their own or being the grantor of their own trust, and the other spouse, the opposite spouse, being a permissible beneficiary of their trust. So what that allows is, if there was no estate tax, they could dump all those assets out to each other. It's like an escape hatch. Also allows for the living benefits of a life insurance policy to be accessed, or anything else you might put in that trust. You want to make sure you avoid something called the Reciprocal Trust Doctrine. Without getting into detail about what that is, or a lot of it I should say, we want to make sure that each trust has slightly different powers than the other. They can't be mirrors of each other, and maybe the timing's off. We'd have one established a month earlier so than the other. But assuming we did those steps, we'd also want to make sure that we considered making all ILITs. I generally recommend that all ILITs be designed as idiots to begin with, meaning intentionally defective, and have those powers inserted to be swap assets or sell assets to the grantor, etc. But the reason why we want to do that is that we want to make sure that this design, we don't need additional trust down the road because we didn't consider the possibility of using it for anything else but holding life insurance. So that's a mistake typically. The other thing is we might want to consider individual life policies or survivorship policies, one survivorship policy in each of these trusts. Oftentimes survivorship policies are used because they're 10 to 15% cheaper than an individual life policy, and this pays out when it's needed at the second person's death typically. But that also assumes that the survivorship policy is cheaper because both spouses are surviving to some age within proximity of each other dying. But if one spouse died significantly earlier, it might have been cheaper to have individual life policies, in the sense that the premiums would have stopped in one policy and the death benefit would have been invested, etc., etc. Additionally, we might want to have, instead of naming the spouse using their actual name in each spouse's trust, the opposite spouse's trust, we want to just name a spouse, meaning if they were ever married to anybody, if one person was to die early and got remarried, they'd still be able to access the benefits of that trust, for example. And finally, you want to make sure that each spouse's trust is funded with their separate assets. You need to be able to fund it with non-marital assets in each trust to avoid any portion of it coming back into the estate. So the next step we would want to make sure is we coordinate between the revocable trust then and the new trust, irrevocable trust we'd be setting up. And so to the extent that a revocable trust created a credit shelter trust, rather than creating some new trust and not referencing the existing irrevocable trust, we might as well have the irrevocable trust that exists now be the credit shelter trust, or consider that. And finally, we want to make sure that to the extent we establish these intentionally defective grantor trusts, ideally assets held in trust would be high basis assets, and low basis assets would be held on the balance sheet. So oftentimes when assets are sold to revocable trust, it might be a business interest, which is low basis, but over time, as things were sold on the balance sheet, you might want to swap them out. And so, and get us to capture the step up in basis that would happen on assets on the personal balance sheet versus the capital gains that would be subject to in the irrevocable trust at some point. If you have any cases you'd like to discuss at some point, please look us up or give us a call. My contact information is here. Thank you so much. Bye.